Assalamualaikum warahmatullahi wabarakatuh. My name is Saibah Binti Musa, student ID 2020956719.
Hello, my name is Irsyad, Hamdi bin Izzat.
Hi, my name is Syazwanie Binti Masri, matrix number 2020956857.
My name is Izzatur Balqis Binti Jaini, number matrix 2020956765.
My group and I will be discussing all about statutory requirements of directors.
I will explain about statutory requirements regarding director. Every corporation in Malaysia is obligated to have one or more directors. Every director of Malaysian business must also fulfill specific tasks and obligations. In Malaysia, a private business must have at least one director, while a public corporation must have at least two directors. Companies Act 2016 defines who is deemed to have close ties with directors. Members of the directors' family comprise the first group. These individuals include the director's spouse, parent, child, which also including step-children or adoptive child, siblings, and spouse of the director's child or sibling. The second category includes legal entities that are closely related to the director.
So today I will explain whether the appointment of Robert and David as the directors of Ikan Emas Berhad is in accordance with the requirements of Companies Act 2016. So as stated in section 196 subsection 2 of Companies Act 2016, that the director of a company should be a natural person who is aged at least 18 years old. Besides that, it was added in the section 196 subsection 4 Companies Act 2016 that the minimum number of the directors shall reside ordinarily in Malaysia by having a principal places of residence in Malaysia. For example, a case regarding on the residence of the director, which is from Poh Yok versus the Central Construction Co. M. Sdn Bhd, which illustrated the requirement of being a resident of Malaysia for the office of director. The court held that the term residence indicates residence in one place with some degree of continuity, where a person who resides at other places than Malaysia would not entitle him to claim the residency in Malaysia. Okay, so now I will move to the section 198 Companies Act 2016 that has mentioned several situations where a person is disqualified from appointed as a director. So as mentioned in the section 198 subsection 1, that a person shall not hold office as a director of a company or whether directly or indirectly be concerned with or takes part in the management of a company if the person is an undischarged bankrupt, and this means that has been declared as insolvent by the insolvency department. Thank you.
Other than that, according to the section 199 clause 1 of the Companies Act in 2016, the court may, on application by the register, make an order to disqualify any person for acting or holding office as a director. The application of this section regarding to Roberts and David's situation, their application to be directors of Ikan Emas Berhad was disqualified by the court. This is because they are not long-term residents here in Malaysia, which was stated in section 196 clause 4. In a matter of fact, both of them are from Singapore. In conclusion to this question, the application of both Robert and David to become directors of Ikan Emas Berhad was not fulfilled. This was due to David's bankruptcy in Singapore and Robert was not a resident in Malaysia.
Director is a title to a person who has been appointed by members to lead or direct the company. Director is an important person in the organization. Employee need and approval of director in any matters related to the company. It means anything happen in the company must be known by director. Before to appoint a director, he or she must at least 80 years old and make sure has a mental stable and rational mind. The director name must clearly from any blacklist and bankrupt. There are few types of director, which is executive director, non-executive director, independent director, nominee director, alternate director, associate director, de facto director, and shadow director. A person with the title of director will be disqualified from being a director and removed from the company whether he or she is directly or indirectly involved with the company if he or she has lost their requirement.
As stipulated in Section 1964B Companies Act 2016, qualification to appoint a director is not include the alternate or substitute director. As a result, if the minimum number of director is to be met, the alternate or substitute director cannot be counted. In Section 198 Companies Act 2016 has listed numerous scenarios in which person is ineligible to be nominated as a director. According to subsection 1981, a person shall not hold office as director of a company or be directly or indirectly concerned with or participate in the management of company if the person is undischarged, bankrupt, which means the person has been declared insolvent by the insolvency department under section 213, 217, 218, 228 and Section 539 of Companies Act 2016. Persons who are declared of an offence relating to promotion, formation or management of a corporation or convicted doing offence relating to bribery, fraud or dishonesty is totally disqualified from hold the title of office director in the company. As stipulated in Section 2061 Companies Act 2016, a director may be dismissed before the end of the director's term of office, subject to the constitution in the company of a private company, which is by ordinary resolution, or in the case of a public company, which is accordance with this provision of the Companies Act 2016. Regardless of what is stated in Section 2062 Companies Act 2016, what is the constitution or any agreement between a public company and a director. The company may dismiss the director by ordinary resolution at a meeting before the director's tenure to remove a director or to appoint another person instead of a director at the same meeting in Section 2063 Companies Act 2016. In the case of David, the company members may dismiss David as a director before the expiry of his office term since he is unable to serve as a director owing to his bankruptcy in Singapore that has not been discharged. Members of Ikan Emas Berhad can remove David as a director by passing an ordinary resolution, and a resolution to remove a director requires particular notice. In conclusion, directors are individual and parties responsible for managing and administrating the company. The director is the company's core and they are the key to the success company. The company management should be in the hands of responsible individuals who can utilize their authority wisely, as a greater power comes with greater responsibility. Becoming a director is a serious and biggest responsibility. It is very important for the person who hold the director title to know his potential and his duties of the position in the company. In the event of an overlap of interest, the director should be responsible for disclosing his or her interest. This failure to disclose may be counted as a breach of fiduciary responsibility as a director.
That is all for my group. Assalamualaikum warahmatullahi wabarakatuh and salam sejahtera.